and thank you for joining Tips for Importing into the US. This is hosted by the SBDC at FIU. And in case you haven't heard of the SBDC, the network is funded in part by the US Small Business Administration. The SBA is an agency of the federal government, and America's SBDCs are nationwide. There are definitely over 1,000. I think there may be even 1,300 across the country. And so any business located anywhere in the US has access to a center. In the state of Florida, we are geographically organized, and FIU, the SBDC at FIU, works with businesses located in Miami-Dade County and Monroe County. And as you can see, there are SBDCs at FAU, at USF, at UCF. And let me remind you, there is a poll. As you're logging on and the pop-up appears like it just did with me, please answer the poll. There will be some polls during this next hour. Each one of these centers in the state of Florida and across the nation has a team of business consultants, not just one person or even a handful of people to help. There are dozens of people available to help businesses. And this is Miami-Dade County and Monroe County, but each one of those centers that I showed you in Florida has a team like this. I think that there may be some of my colleagues or team members from FIU or other centers attending. So if you're there, I'm shouting out to you. Feel free to shout back by writing your name and email address into the chat. And what we do is provide one-on-one business consulting. So this is confidential, it's personalized. It's just like this, a virtual meeting with a business owner just to address the needs or the opportunities that the business is facing at that particular point in the life cycle of the business. And the business will be matched up with the appropriate consultants. So each one of the people on a team have different career backgrounds and different knowledge that they can share with a business. And speaking of knowledge, we also have subscriptions to databases where we can do market research and download data and provide information to businesses that they would otherwise not have access to. My name is Shelley Burnell. I am at the SBDC at FIU as a business consultant, and I am privileged really to be able to work all day, every day with small businesses, the owners, as well as every member of a team of a small business. I tremendously, anyone who works with me knows that I tremendously admire and respect business owners and teams of small businesses. This is a heavy lift. And I view these people as being the most productive and efficient in our society. And speaking of these people, I'm going to segue into the introduction to our speaker, who is a business owner and has a small business, Diaz Trade Law, Jennifer Diaz. Jennifer is not only one of the most off the charts intelligent people I know. She is like a sponge, absorbing knowledge and information. It seems like an endless capacity to learn, combined with this incredible desire to share and disseminate that information and that knowledge. So I am really honored and grateful to you, Jennifer, for joining us today and bringing your knowledge and sharing your guidance to the small businesses and the business owners who are joining
It's a wonderful resource for our businesses. I used it when starting DTL as well. My company is in its 8th year, been practicing for 18 years. I'm a board certified international attorney, and there is so much to talk about today. I love that you're using the chat box. You will have a whole lot more by way of polls, and I really want your questions as we go. So feel free to, oh, thank you. There are some nice comments in the chat box, which are really sweet. So I appreciate that. You're making my Valentine's Day heart flutter, which I will take all day. We are going to talk about all sorts of things on importing. I highly recommend everyone have a lawyer. It's part of your toolkit. You need a great customs broker, which we'll talk about. You need a customs lawyer as well. I hope it's me, but if it's not, have a customs lawyer. Make sure you put that in your toolkit. I'm going to talk about the status of importing and my thoughts. Everything is generic in nature, and your business has your own specific requirements and thoughts as well. So every situation a little bit different. Everything I'm talking about today, you know, lawyers, we always have these disclaimers. Get your own lawyer as part of your toolkit. I urge you. Lots and lots to discuss because customs is enforcing, and I get to thank God for customs enforcing every day because that absolutely gives me a job. But in fiscal year 2022, customs seized 27,000+ shipments, and over 10,000 of them, or 39%, were for intellectual property rights reasons. We're going to talk about today. Customs issued over 1,000 trade penalties and 9,000+ liquidated damages claims. That's a lot. I mean, fiscal year 2021 had 83,000 seizures and so on. Bottom line is there are always going to be seizures. There's always going to be enforcement. We don't want anyone here to have to go through the pain of the seizures and forfeitures and the penalties and so on. So we're going to talk to you about being proactive. I see a lot of you in the chat box. You're newer to importing, and this is the place to be. So we're going to talk about what to do, what not to do, proactive examples and such. So as we start, we're going to have polls. Yay. So I'm going to post it right now. And the first thing I want to know is, who are you? So I saw a few of you answer the poll, the chat box, that say that you want to be an importer or exporter, you are, or so on. Or you're a broker, you're a forwarder, are you manufacturer, are you in-house legal, are you product development, are you just interested in the topic? So it's nice to be able to get a glimpse of who we have here. So I'll give you guys a couple more seconds to pounce on the poll. And we are going to have a lot of these, and I really want this to be interactive. So as you have questions as we go, you do have your Q&A box. Use it, embrace it, and ask questions. If you want confirmation on something, have questions on something, want to discuss something, want to further elaborate, I'm open. Let's do it. All right, perfect. The majority of you are importers and exporters, which is great, and that's what my expectation would have been. We do have a decent chunk as the second runner-up as brokers and forwarders, which is similarly perfect. There's a lot that I like to discuss about the role of the broker forwarder versus importer and where that line should start and stop, and that gets to be a dicey, sexy conversation. Manufacturers, in-house counsel, product developments, and some people that are just interested in importing. So thank you for taking that poll. Get started. We've got DHS. And I see some questions coming through in the chat box. I would love it if you don't mind, if you can put them in the Q&A box so we can answer them as we go as well. China's a hot topic. We're going to get there. Stick with me. So first, let's lay the groundwork for you. So we have DHS, the Department of Homeland Security. And underneath that, we've got CBP. Huge role. Imagine securing our nation's borders. Not exactly a pleasure all of the times. We've got 328 ports of entry, and you've got U.S. Customs, 60,000 employees securing 328 ports of entry. So Customs has to protect our borders, and they have a whole lot of other responsibilities. Protect the security of the U.S., protect the economy, prevent unsafe products from entering, protect consumers and businesses, making sure that everything that enters meets free trade agreements and all necessary requirements. This is a virtually impossible job, but lots of help with AI, lots of machine learning. I mean, Customs is even using blockchain right now. Super cool. There's so much that Customs is doing to keep up with the trade and to keep up with targeting and how they pick who's good, who's bad, and who needs to be looked at a little more carefully. But one of my most important and favorite roles of Customs is facilitating legitimate trade. That's the angle that we're going to talk about today. But in order for customs to facilitate, so CBP is Customs and Border Protection. So U.S. Customs and Border Protection under the Department of Homeland Security. So I don't want you to think about CBP. Lots of acronyms in this business, so please feel free to ask because it's nonstop acronyms. You're going to be a pro in acronyms in, as soon as 5 to 10 to 15 to 20 years by the time you're in this profession. Every broker and forwarder in the room, you know your acronyms. We've got 47 federal government agencies that regulate trade, imports, and exports. And you've got a lot to do. We're going to go through all those fun tips with you, all these fun customs concepts. An entry summary, this is your 7501. This is like the juiciest piece of info that U.S. Customs gets digitally. Yes, you are getting a copy of the PowerPoint. Yes, the customs, this PowerPoint, and this is being recorded, so you will have access to, for sure, the PowerPoint. SBDC will decide about the recording and let you know. When it comes to basic customs concepts, okay? The 7501 is the most important doc. This is your entry summary. This gives customs all the juicy intel. This is in addition to your ISF. So before your cargo leaves on a vessel via ocean, you file your ISF, your security information before, so customs can decide whether or not you're going to be vetted, pulled to the side or not. But the 7501 is your entry summary that has more juicy details. Everything I highlighted are the fun things that I like to look at in addition to everything else. Your entry number is one of the most important numbers. So one important tip I'm going to give you today is when it comes to record keeping, I beg of you to not just think about your bill of lading, your customer's invoice number, your PO number. I beg of you to think of your entry number. So what I like to see in my client systems is you've got your invoice, bill of lading. I don't care what that secondary number is. And you've got dashes and you have the entry number. That's box 1 of your entry summary. So when you're saving your records that are associated with your particular file, save them by entry number. If you learn nothing else, please take that. Because when customs has questions for you, they don't know necessarily your purchase order, your commercial invoice number, however you save docs, they know your entry number. So when customs wants info, they're going to ask via entry number, so save that. The country of origin and so on, we're going to talk about all these other sexy highlights as we keep going. Lots of basic customs concepts in terms of if customs has questions for you, they ask in the form of a request for information. That's interesting. Somebody said that their PO number is the entry number for imports, and that's very interesting to be able to do it that way. I don't see how that could technically work. I'm very curious, and I kind of want to see your system because the entry number would always take place after the order has already been ordered. Normally, your progression is you've got a purchase order, a commercial invoice, you're sending that invoice to your broker that's then proceeding with your customs entry thereafter. So normally your PO would be before your entry number. But if you have a system that can reconcile those numbers, I love it and would love to see more of that. Now, if customs has issues with anything that you've submitted, really it's your broker that's submitting this entry summary on your behalf. So do you need a customs broker? Yes, you absolutely need a customs broker. You have to file that entry when your shipments are valued over $2,500 and they're a commercial importation. Everybody's not ordering off of Amazon for personal use here. We're here because you have businesses. So when your businesses are buying goods worth more than $2,500, you must file that entry summary and you must have a customs broker. A few things I want to teach you about your broker relationship because that is the most important relationship. Interview your broker and know who your broker is. There are brand new broker regulations that have just come out that have just started in the final roll stage, and they're official. It's part 111 of the broker regs, and we're actually going to be talking about that with Florida Customs and Brokers tomorrow. So if anybody has questions on that or wants me to fill you in, you have until today to register for that because the updates to part 111 are huge as far as brokers are concerned. You need to be up to date on that. But as the importers, because most of you are importers in the room, I really want you to think about your broker understanding you and your particular products. So what I want you to ask your broker is, do you deal with my commodity often? Let's say it's food, for example. And if it's food, do you also deal with FDA often? Do you have a good understanding of FDA? What happens if my shipment is detained and or inspected or seized, or if there's a problem, what is your communication style with me? How are we going to jive? How are you going to communicate with me and tell me? If I have a question or issue, who's my point of contact? Depending on the company, sometimes you can get assigned your own point of contact. You need to be close with this broker. You need to know who they are. You need to have a point of contact, and you need to have a good communication flow. Now, if you want to make your broker happy, have a compliant commercial invoice. Number one thing we see wrong when we look at docs is the commercial invoices are not in English, and they don't contain all of these juicy required docs. This is my cheat sheet for commercial invoices and a sample commercial invoice, for example. Now, there's a brand new requirement that's starting March 18th where you're going to need the zip code for the manufacturer. How many of you know the zip code for your manufacturer? And why is customs doing this? Because there's a specific region in China that's known to produce goods with forced labor. And customs is purposefully targeting that region and the zip codes via that region. So they're mandating, customs is mandating that you utilize the zip code. Well, that means you're going to have to get the zip code. Where are you going to get it? My recommendation is on your commercial invoice where you have the seller name and address. You make sure that that number one seller name and address also ensure that you know that that's the manufacturer, not the manufacturer, and get the zip code then as well. So make that part of your invoice practice, and then you're making your broker happy too. Other things that we absolutely see that are not correct with invoices is the currency. You always want to make sure that you say what currency it's in. We often see descriptions that are abysmal. If you have a SKU or a product number, that's not an adequate description of your goods. The description should be juicy enough and detailed enough for us to understand how to classify those goods. We're going to get into what that means in a few minutes. So all sorts of tips on this cheat sheet for invoices, but you're going to make sure that you have a happy broker. And it's a good question in regards to manufacturers being in a country that doesn't have a zip code, because this is going to wind up being a requirement. So what customs is doing long term that I think is super juicy is they're changing, and I'll go back for 2 seconds just to illustrate this. On the 7501, this is long term, not short term. It's in a test environment right now, the manufacturer ID, because that's based upon the address and country and name of the company, but it doesn't necessarily incorporate a zip code. But for UFLPA enforcement, the zip code's going to be a thing. So it's going to be a problem if you don't have one. You're going to have to figure out another solution for not having a zip code, because this is more so geared towards China per se, for China targeting for UFLPA. So Tanya, for your particular question, I'm very curious if your particular manufacturer is in China or outside of China. If it's in China, there's a zip code. And that's really what's being targeted here. All right, let's get into our tips, because there are so many of them and so many juicy things to talk about. The first thing that I see that companies get into a whole lot of trouble for not doing their homework on is who regulates you. If you heard me at the beginning, 47 agencies to choose from. So I've got cool examples of an adorable little motorcycle. And the motorcycle has handlebars that can pop right off. And there's candy inside this cute little motorcycle. Well, now I've got multiple federal agencies. You always have U.S. Customs at the center, and then you have all these other government agencies on top of U.S. Customs that's at the border. In this instance, the candy is FDA. The handlebars that can chop right off and that can become a choking hazard for kids, big issue in regards to choking hazards. So now you've got CPSC, you've got FDA, you've got U.S. Customs. Who regulates you? Now, in some instances, we see a lot of small businesses, unfortunately, they wind up having to go out of business because they don't think about anti-dumping or countervailing duties. They're not thinking about forced labor, which is the hot issue right now as well. There are so many fun things to think about when you're starting your business at the beginning. And I urge you, if you take nothing else, to take this. Compliance isn't something you get to throw by the wayside and to push for the sale without thinking about compliance. Because unfortunately, if your goods are not compliant at the time of importation into the US, meaning they should be compliant before they leave the supplier's place of exportation, before they physically arrive into the US, then you're behind the 8 ball. You haven't done all of your juicy homework yet. All right, a question came in. FedEx offers electronic commercial invoices. Is this better than hard copies? Super juicy. In regards to electronic invoices, I don't mind them as long as you really have all those requirements. Now, what FedEx does is they populate all those sexy things that the regulations require. My question for you then is, are you saving a copy of that for yourself? Because if you're not, you're doing yourself a disservice. So you want to be sure that you have a copy of whatever that invoice is. Another thing that I like my clients to do with FedEx and UPSs of the world is I've often seen that the supplier dictates to the FedEx's, UPS's, the big carriers, what the value of the importation is. And quite often that may not be accurate. So we have what's called a stop and validate, stop and verify procedure with you. If you're the importer of record and you're taking liability for the shipment, then you reconfirm the value, you reconfirm the descriptions, you reconfirm the quantities, you reconfirm the information to ensure that it's perfect. All right. Lots of government agencies. When it comes to vehicles, we're dealing with DOT and EPA. Every product is different. Every product has its own set of requirements. So the first thing is, what's my product? Who regulates me? What are their rules? If it's alcohol, for example, we need TTB and you need an importer's permit. Everything is different for every single product, and knowing your requirements in advance is huge. If you're dealing with CPSC, they have a very cool regulatory robot that I love. If you Google CPSC regulatory robot, pops right up. So bottom line for you, you have to think about what you're importing, where it's coming from. Now, especially, you also have to think about forced labor and ensuring that there's no forced labor in your supply chain. There is a US LPA entity list that you should be looking at and ensuring you're not buying from them. If you do, customs will stop the goods and say, no, thank you. There's a hard and fast rule that you cannot import goods made with the use of forced labor. That's our rule. Anti-dumping is also something that's difficult to navigate and look up. And the bigger aspect of all of this is what I hear the most of is, but I have a customs broker. They're going to do all this for me. They're amazing. I get it. I get that your customs brokers are amazing, and I do not doubt in any way, shape, or form that they serve a ginormous function. But there is a line, and it's an invisible line that a lot of people jump all over all the time. But the broker is responsible to submit the entry to customs. They are not responsible to be your external compliance department. It's above and beyond. The broker is responsible to supervise and control the entry process. The importer is responsible to use reasonable care. We're going to talk about that. Another thing that we quite often see that companies don't know is their Incoterm. If you don't know your Incoterm, you haven't heard of an Incoterm, then you've got to read this. It's required reading. When does the risk of loss pass from the buyer to the buyer from the seller? It's a big deal. So there's all sorts of Incoterms from DDP to experts. There's no such thing as a right answer or a wrong answer. It's just a matter of knowing who should be buying insurance and when the risk of loss passes from the seller to you, the buyer. Textiles can require quotas. That is absolutely possible. When it comes to government agencies that deal with food, it's very, very specific. When it comes to food, you've got potentially USDA, FDA, and US Customs. So lots of potential homework to do when it comes to food. When it comes to TTB and alcoholic products, that is something that we assist with, where we can help our clients become importers and wholesalers of alcoholic beverages. Lots of rules when it comes to alcohol and every product. So that's your tip one. Another quick read, if you're not up with the latest and greatest on what's going on with forced labor, you very much need to be. This is the new hot topic and one of the new priority areas for customs. Next thing we're going to talk about is intellectual property rights, one of my favorite topics, because I am positive that a whole lot of you have brands. And if you have a brand, we should be talking about how you protect that brand. And there's a fun program that we're going to talk about, but now you're going to tell me yes or no. What do you think here? True or false? Do you think US Customs has an amazing program that will protect your intellectual property rights, which is your copyright or trademark, when you record it with US Customs? So I don't know why this program is not as heavily broadcasted or loved. We actually put on a social media program called Lux Trademarks, because you'll see the cutest dog in the world soon enough. And we try to let people know what trademarks are in fact recorded with customs. So thankfully 67% of you said true, and you are all 100% correct. It is, I think, one of the coolest programs that customs has. Now, this isn't about patents. This is about trademarks and copyrights, very, very separate. So when it comes to patents, a whole nother process. So that one we're not going to talk about today, because patents is a whole nother ball game, and customs doesn't necessarily protect that the same way. You need to get an exclusion order with ITC. It's a whole nother ball game for patents. Today we're focusing on trademarks and copyrights. When it comes to copyrights and trademarks, and when it comes to your products, I've got a few suggestions and thoughts for you. So I'm going to start one forward and go backwards. When it comes to your own brand, the first thing you should be doing for your brand is registering it with USPTO, which tells the world, this is my brand, it's mine, that's your TM. When it comes to registering officially and getting your official confirmation that you're officially registered and done, that's when you use your cute little R. Now, customs will allow the recordation of registered trademarks or registered copyrights, meaning you have to do your homework first. You have to register your copyright. Typically 90+% is trademarks. We're normally dealing with the trademark side of the house. And it's $190 per international classes customs fee. We charge an additional fee as a service provider, and anybody else would charge you that fee. I urge you to get counsel when you're doing this, to do it right. When you finally get the recordation, it would look like this on the CBP's IPRS recordation site. I've given you the site on the slides as well, where you can search them. Now, it's really important to do your homework and to search whether or not a company has recordation protection, because customs, guess what they get to do? If you take the time to protect your brand with customs, customs protects you, meaning customs polices that brand at all 328 ports of entries, meaning customs will not only detain and seize your goods, but customs also gets to issue you a penalty for messing with someone else's recorded trademark, and also tells the recordee, meaning if I recorded my brand with customs, customs will tell me that you tried to counterfeit my brand, and they'll give me your name and address so I can go after you with a cease and desist. All of this to say, it's a very, very inexpensive way to protect your brand that you should know about and take advantage of. Now, as an aside, if you're importing a toy, alcohol, I don't care, whatever the product is, apparel, doesn't matter what the commodity is, and there is a brand on that product, whether it's, for example, Abbott or any of these brands, do you have authorization to utilize that trademark on your product? Because if you don't, you're in all sorts of trouble. Then you need to know if that trademark is recorded with customs, because then customs could be actively policing against what you're doing and looking for you and finding you. Not what you want, and not the way you want to start a relationship with customs. It's not a juicy good one. If you know anybody that is messing with your brand and or importing an item that contains your trademark on it without your authorization, customs has a very good program called e-allegations to report the bad guys. A lot of you may be doing business in China. There is a separate process to protect your brand in China. That's something we talk about here. So I urge you to check this out. If you're in China, doing business in China, or have your brand ongoing in China, if you're making products in China, protect your brand in China. Very different system than the United States. This article goes into the ebbs and flows and all the differences between the US protection and China protection. All right. Moving on to our next poll. Let's see how you guys do. We're going to launch it. Customs holds the broker. So if you guys were listening, and I know I speak fast, so sorry, responsible to use a standard of reasonable care. And this is for the broker. And the trick here is there are two parties in every transaction here. You've got your customs broker and you've got your importer of record. I don't assist with Japan laws. What I assist with are US laws. So it could be a company in Japan making product, for example, but when it comes to my role and my practice, it's all about the United States laws and how US deals with importations and exportations. So it doesn't matter where the goods are manufactured per se, but our assistance is for the US side. All right, when it comes to, this is a hard question, so a lot of you guys are getting this one wrong, which is okay. So we'll let everybody vote for a couple more seconds. All right, good. I'm going to end the poll. So actually only 47% of you got it right because this was a trick. This is false. Now let me teach you again, and let's make sure that this steers clear and that we get this, okay? Now, the way it works is when you're importing, the importer of record, which is the majority of you guys here today, are responsible to use a standard of reasonable care. And lots of tidbits of information you're going to get today, but I consider this slide required reading. If it was me and I was in charge of customs, I would be hated by importers because I would really require importers to read this at the bare minimum. There's a 200-page guide on importing into the US that I think is even better, but this is a very short 15-page worth of text here. Not a whole lot to read, and if you can't read this in my book, you can't import. So in my world, you have to read this and take a test. I would boil it down to 10 questions. I could come up with 10-question tests because if you don't truly understand your liabilities and obligations to utilize reasonable care, and this article goes into the weeds on what you have to do as an importer to use reasonable care. I urge you to read all of these things. I know I'm giving you a lot of homework that you may or may not like, but you really, really, really do have to read this. Then it's a toughie. So this one, everybody should get right now. We're going to launch this poll, and I urge all of you to think about what we just said and then tell me that you really get it. As an importer of record, you must have a process in place to use reasonable care to ascertain, and then all the other things we're going to talk about next, which is classification, value, country of origin, and such. Good, good. I am so glad you guys are listening. I love you. Fabulous. Wonderful. 100% of you are listening, and I love each and every one of you for that. So thank you. Good. It is the importer of record that has to use reasonable care and the customs broker that use reasonable supervision and control. Okay, no. So let's do that one more time. Okay, I know I'm fast, so thank you for asking the question, Marissa. The IOR, importer of record, must use reasonable care. The customs broker is responsible to use reasonable supervision and control. Very different than reasonable care. Reasonable care means that the importer is liable for the classification, valuation, country of origin, forced labor, IPR. The broker is different. So different words in terms of the broker's rules. Yes, everybody's going to have the slides. All right, as an exporter, if we have a kit made specifically for our company with one component, can this be trademarked only with customs or also with an additional entity? I'm sorry, Deborah, you're going to need to give me more info. I don't understand enough about specifically what you're asking, but when it comes to trademarks, if you have the ownership, meaning if it's your brand, then you have the right typically to register it. What typically when it comes to protecting your brand, my preference is that you do a search first to make sure nobody else is, well, let me tell you one story on trademarks and brand protection, because this is a biggie that will hopefully illustrate the point. We had a client that was so excited about their brand, and they went straight to marketing and straight to printing all sorts of sexy labels for their product. And they spent a lot of money and a lot of time. They designed their sexy trademark. They printed their trademark. They put their trademark on all sorts of goods. And we said, we're not even done with our trademark search yet. You got to slow down. We did our trademark search, and we found that there was another company with a very similar name, and they did not have a very good likelihood of winning the trademark registration. There was probably going to be a battle because somebody else had gotten there first. No, we want to go for it. Okay, well, that company battled, and they wound up not being able to go forward with their trademark registration and wound up losing the rights to all the stuff that they did, and then the potential lawsuit on top of that. Not anything anybody wants to deal with. So before you utilize any sort of trademarks on any part of your product or kit, make sure you have the right to utilize that trademark. And if you have ownership of it, you can protect it in the US and in other countries around the world. Talk to your lawyer first about where you should protect and why. There are strategies to utilize for that instead of doing it haphazardly. The customs broker should never, ever, 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 ever be the importer of record. Those are very separate parties. And when a customs broker acts as an importer of record, I get very upset with them. So if you have me as your lawyer and you are a customs broker, I will yell at you all day from here to Sunday about never, ever, ever being the importer of record. The importer of record bears the liability for the accuracy of the statements that the customs broker makes to U.S. Customs. But the importer of record and the customs broker should be separate entities, not the same. All right. A lot of you have all sorts of sexy, juicy questions about classification, and this is where your fun China tariffs come into play, so listen up. Every product imported into the US requires a harmonized tariff schedule of the US. Now, I love this tool. It's in the top 10 tips that you're going to get, and you're going to see in really small letters here, you've got 08 and 0808. So we're just doing apples, super easy, right? So it starts with the chapter 08, and then it gets to the heading, the next two. So the first two numbers, chapter, first four numbers, heading, first six numbers gets into your subheading, total 8 numbers, your subheading, and then your last 2 numbers are your suffix. With the site that I've given you, it's an interactive HTS schedule. I do want to tell you like 10 things, so listen up. 1, when it comes to your HTS, it helps determine the amount of duties, because the number one question everybody wants is, I don't want to pay so much in duties. What's that best number that I can get the least amount of? No, it doesn't work that way. It's annoying, but the way it really, really works is you classify based upon the description and intended use of your good at the time of importation. So are you importing an apple that's valued under 22 cents per kilo? If so, 0808100030 is your HTS. Is it certified organic and valued over 22 cents per kilo? Great. Then the suffix last 2 digits are going to be 45. Now, the coolest part about what I'm showing you is you see those last 2 digits here. It's interactive, meaning when you're on the live link, you get to click on it and you get to cross. Cross is the customs rulings online search system. In Cross, you get to see if customs has been asked similar questions about similar importations that you can compare to your own to help make a decision about what the right classification is for you. So when it comes to the site, let me go through it again. The top is HTS, US, and ITC. So when we get all the way to the end, you're going to see it on my top 10 tips cheat sheet, but it's the live HTS from the ITC. A lot of acronyms here. It's not going to matter as much. When you get to the site, you're going to see it, and you're going to love it, and you're going to learn it, and you're going to be all over it. Now, to get to the juicy parts of what you really want to know with the tariffs. So let's go back to our apples, right? So our apples valued over or not over 22 cents per kilo, ending in 30. You see where it says, first, you have your unit of quantity. That's your kilos. So another thing I want to see is when all of you look at your 7501, that doc I showed you at the beginning, your quantity should never be 0. I see a lot of 0 quantities. Why are you importing if you're importing nothing? That makes no sense. So here from your HTS, you get to see the unit of quantity that your broker should be reporting on your 7501. Then you go to your general rate of duty, and that's for our most favored trading nations, everyone we love. So generally, it's free. But if you look really closely, do you guys see that little 1 next to the free? That 1 means there could be an additional tariff. That is the China tariff that we're talking about. List 1, 2, and 3 are 25%. List 4A is an additional 7.5%. I know there are 1,000 things we can talk about as it relates to China tariffs. And many commodities are absolutely paying this 25%. And the way you find it is based upon this little 1 right here. So we're not going to get into the equities of whether or not paying is right, wrong, or so on. I'm not an economist or such. And maybe if you get me a few drinks after hours, I'll talk about how I feel about these things. But right now, what we care about is what the law is and how you apply the law itself and how you know if the 25% does or doesn't apply to you. Because what I want you to come out of this with is preparation. Because when you're coming at the beginning of this and understanding whether or not the tariff does or doesn't apply to you, you've got to come up with your cost to your customers, right? It's a big deal. So in regards to the tariffs itself, they're very much in place. There are very few exclusions that are currently in place. They're usually COVID-related exclusions and very few. And there's a lot of homework you have to do on your side to figure out if there is or isn't an exclusion. The USTR has a great site for China tariffs, but honestly, it's over most people's heads. Usually you need a consultant or you need a great broker that'll look at that with you. And I urge you to get compliance assistance for that particular question. What we're seeing now are more and more people using exclusions that they don't have the right to use. And now Customs is sending bills saying, I gave you a refund, but I shouldn't have. I want my money back. Imagine that. We have clients that could or could not go out of business as a result of that. So take this seriously. The right classification is a big deal. And when it comes to classification, I've got two amazing resources for you. One is this talks all about tariff classification basics and gives you all of the 411 on how to classify and how you get there. This are the top 3 questions in the reasonable care checklist. Remember that guide that I told you was required reading for importers? These are the top 3 types of questions that I want you to think about. Before you start classifying, you have the option to request a binding ruling from US Customs. Guess how much Customs charges for this binding ruling? I think it's a wonderful service they provide. They don't get enough clout for this either, but it's free. Customs doesn't charge anything, but I will give you a couple of caveats. When you ask for a ruling from Customs, I like to have 2 rules myself. One, I want to know, A, what I'm arguing, and I want to argue for what I want within my request. So you want to make it a persuasive ruling request, and you want to ask for what you believe Customs should consider. And you also always want to tell Customs that you want to talk to Customs if they disagree with you, because the regs give you the opportunity to have a conversation with Customs should they disagree or have questions for you. There is an online process to request a ruling. You need a lot of detailed information about your product to do so. And you also need an expert. And if you don't have the expertise internally, then you've got to get it externally. If you are not paying your broker for this type of compliance advice, I'm sorry, but it's not really advice. You need to pay your broker for compliance advice that goes above and beyond. And classifying your goods appropriately, I have a lot of battles with this back and forth, but to me, this is something, if I was a broker, I would mandate that the importer provide me with the classification of the goods for me to process to US Customs. And if the importer wants advice from me on the accuracy of the classification, then I have a compliance team that provides compliance advice for a fee. And I would want a written description of why that HTS is most appropriate for my product. If you don't have that, that's an issue. It's not a good thing. And if you're ever going to claim conditionally free merchandise, for example, you need backup. So the ruling process, again, I think is a really great one. And I just want you to think about that because it's a terrific program that Customs has in place. So know your classification, fine. Tip 5, know your valuation. This is a biggie. When it comes to valuation, okay, so a question just came in about classification. So we'll back up for 2 seconds. Wouldn't we get the HTS code from the manufacturer if all they do is export? So I beg of you to read this guide for the Juan who asked this question, because now your manufacturer and you in the United States, you're going to share an HTS up until the 6th digit. The first 6 digits are unified and harmonized. The last 4 digits are not. And now here's the best part, Juan, and here's my question for you, right? So your manufacturer, what if they give you the wrong code? Guess who's liable? Guess who's responsible? I dare you to tell me that you have a contract in place with your manufacturer that's going to indemnify you if your manufacturer gives you the wrong code. I'd love to see that. It doesn't exist, and you know it doesn't exist. So my answer to you is, if you trust the manufacturer, that's great. But how hard is it for you to go on the website and verify that you're getting the right information? That's what you should be doing. And I like getting the code from the manufacturer, but I'm telling you that you should only trust that code up until the first 6 digits that's harmonized. The last 4 digits, the manufacturer does not have to be an expert in US law. And what if they give you the wrong code? And what if they tell you, you know, this one doesn't have China tariffs, hint, 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 use that. But what if they're wrong? They can put you out of business. Do you want to take that risk when you're the liable party, not the manufacturer? I beg of you to not. All right, when it comes to valuation, typically value is semi-simple and complicated all at the same time. Value is the price paid or payable for goods when sold for exportation. So Juan bought something from a manufacturer. His commercial invoice says it's $100,000. Great. The price paid or payable is $100,000. Now, where this gets juicy and complicated is if Juan and the manufacturer are related parties. If that's the case, meaning you own 5% or more of each other, your brothers, sisters, or so on, we have a lot more to talk about. That's not the subject of today because that's too detailed for today. Customs has been sending what are called informed compliance letters. If you ever get one of these from Customs, that means they already know that they're not happy with something you're doing. It's time for you to internally audit. So if you ever get a letter from Customs, take it seriously because they don't send letters for fun. They're not trying to be friends with you. They are trying to enforce and collect revenue because that's one of their priorities as an agency besides protecting the borders and facilitating trade. Country of origin is a hot topic. What I want you to memorize is that every item that you import, it better have a country of origin labeled on that item. No, you cannot just use made in the USA if you assemble in the United States. We get that a lot. Made in the USA is a strict standard with strict penalty provisions for using it. And the FTC, Federal Trade Commission, is the entity that one of that many government agencies that regulates the made in USDA claims and truthful and fair advertising to consumers. So the juicy question we get a lot of when it comes to country of origin is, all right, I'm making a cookie and I've got flour coming from Canada. I've got eggs coming from Mexico. I'm using the water and the chocolate chips that are made in the United States, and I'm mixing them all together and they're turning into a cake in the United States. Well, pretty cool, because in that instance, you're transforming the egg, you're transforming the flour, you're transforming the chocolate chips into a fabulous cake. That transformation takes place, for example, in the United States. But now the fun question is, can you really just say made in the USA in that instance? And that gets a little more complicated. So made in the USA is a different standard than made in any other country. Made in the USA is all or substantially all. So now the fun question is, what percentage of the product was made outside? So then you may need to say that eggs are from this country, flour is from this country, and it's put together and baked in the United States, or so on. So there are qualified claims based upon what you're actually doing in the United States. This gets juicy and complicated, but bigger picture is, if you have multiple raw materials and multiple steps within your supply chain, and there's a question about what that final country of origin that should be labeled on your final package, Customs has a binding ruling process to get confirmation from Customs. But here's your poll. So let's see if this makes sense, and I'm going to know from the poll whether or not it does or doesn't to you, and see if you get substantial transformation. Foreign components may be used to manufacture goods that could still be eligible to enter, for example, duty-free pursuant to a free trade agreement. So in this instance, this is a lesson on both free trade agreements and substantial transformation. At the end of the day, when it comes to free trade agreements, there are rules as to whether or not you're eligible for that free trade agreement, and some of that's based upon tariff shift, your HTS changing from one HTS to another. And rules of origin are a whole different ballgame as well. So it winds up getting a little more complicated than I wish it was, and it's not a simplified system, but there are many instances where we do have foreign components, for example, in a final good, where foreign components, let's say, are from China and the good is manufactured in Singapore, and my client's eligible to use the Singapore free trade agreement and not pay regular duties. But we have had instances where the country of origin technically is still China in that instance, and they still have to pay the 301, that extra 25%. Imagine. Not always a pleasure. So some of this gets really complicated, which is why you need to think of this before you start importing. In my perfect world, you have a formal written import compliance program that makes me happy. If you do use a free trade agreement, I'm obsessed with Customs' new system. They've got certificates of origin, and when you click on the top left, you click on the actual free trade agreement, and it populates the certificate of origin with the criterion for eligibility here. I love it. I beg of you to use it and keep records that you really are eligible. We have a whole lot of free trade agreements with the United States and all of these amazing countries. I also love this side-by-side comparison chart that goes over things like de minimis, meaning if I have a really small amount of China components, can I still use the free trade agreement? Lots of questions like that, for example, are answered in the side-by-side chart that I've given you. All right, let's see if you can get this. In regards to our next poll, let's launch it. How long does customs require you, an importer, to keep records of your entries? So I know a lot of you may think about the IRS being 7 years, but I will tell you, it's not 7 years. I know it's easy to think about the 7 years, but in this instance, all right, so far, the majority of you are getting it right. 68, 69, okay, it's flowing. 5 years. 5 years is your statute of limitations. That's how long you must keep records. Now, another fun question and answer session here that we've gotten a lot of. Records are an importer's liability. Yes, a broker needs to keep records too, but you as the importer, you should not rely on all of the record keeping function lying with the broker. That is not the broker's job. It is your job to make sure after your broker files that 7501 that with their invoice, you demand a copy of that 7501 and you keep it. And I want you in your file that's labeled with the entry number, I want you to also keep proof of payment. I want everything from the order to the invoice to the 7501 to proof of payment to proof of delivery to whatever else within their goods to your bill of lading or your airway bill. I want all of it in one file. That's my perfect world because that all of that is your entry packet. Important. Now, there are lots of bad things that can happen if you don't do all the things I told you to do. So yes, it's a lot of work. Yes, it's doable. Yes, it's work. I mean, what fabulous business doesn't involve work? Nothing is fabulous and free and easy. It just doesn't exist that way. If customs is not happy with you, they send requests for information. I will give you a horror story to hopefully scare you into not doing what some people have done. Some people say, request for information, what's the biggie? Let me just toss it aside. No. Worst thing you can possibly do. Sometimes that's the start of an audit. Sometimes it's the start of a penalty proceeding. Customs is not sending you a request for information because they want to get to know you and they want some info about you and they want to hang and they want to be friends. It doesn't exist. They're a revenue protection agency. Do you know U.S. Customs is the second largest revenue producing agency in the United States after only the IRS? They collect gazillions of dollars in duties, and they're consistently looking for companies lying, cheating, or stealing or paying the wrong amounts, even if it's not purposefully. When you get a request for information, this is the time to think about whether or not you should be submitting a prior disclosure. A disclosure is a tattletale system where you say, I made a mistake, Customs. I'm telling on myself. Customs has new provisions in regards to prior disclosures and timeframes that I think are incredibly unfair, but that's a story for another day. So if Customs has questions for you, they ask in the form of a request for information. Now, when Customs sends you this request for information, let's launch our poll. What's your best option? Ignore the notice? I dare you. Respond thoroughly and timely. Communicate with an expert and discuss your options and what you need. Or both. Respond thoroughly and timely and communicate with an expert. I beg of you. I see too many people that unfortunately wind up losing their businesses because once this all goes south and Customs isn't happy with you, it is unfortunately likely, we see it often, where you wind up with penalties. And now the idea is you didn't pay your China tariffs where you should have. Well, did you do it negligently, gross negligently, or fraudulently? And if it's gross negligently, Customs can issue a penalty for 2 times the loss of revenue. Fraudulently up to the value. It's really, really high. All right. So now, when it comes to mitigation of these penalties, one of my big things is never pay without a fight. When you file a disclosure, lots of specific provisions within the disclosure that help. Meaning, if you tattletale, if you get a 28 and you wind up telling on yourself, then instead of having to pay 2 times the loss of revenue, you just pay interest. You make Customs whole with what you should have paid, and you pay interest, and you're square. You don't get 1,000 of these freebies with Customs, but it's a great program and something to take advantage of when the situation warrants. Now, if you don't respond to the request for information timely, customs will send you a notice of action. A practice that I am seeing from customs that I don't like, that I'm seeing more and more of, is customs is bypassing 28s, which they shouldn't, and they're going straight to 29s, notices of action, taking action. Normally, you get a 28, you have the ability to respond, and then you get a 29 proposing action, and you have another ability to respond. If customs takes action here, your only option thereafter is to protest. The bottom line is there's a very specific administrative process to fight because customs doesn't always get it right. And it's okay if they don't. You still have a mechanism to fight. But what I want you to hear is you have very specific time frames to do so. Same thing if you get a detention notice or a seizure notice, you have to be proactive. I always say never, ever, ever pay anything without a fight. It's a critical stage to get counsel involved. Seizures are very specific. You've got 30 days to respond and all sorts of time frames. And the same thing with penalties and liquidated damages claims. You have time frames, and I've seen companies get these because their brokers file their entries late. I've seen companies get these because FDA said, you know what, you didn't care about complying before you started importing. So we're issuing, customs then issues a demand for liquidated damages here in your notice because customs at the same time, let's say, let me give you an example that happens often. You imported food and your food wasn't labeled correctly. Your food wasn't from an authorized color source. You had coloring in it that wasn't authorized. FDA is not happy. FDA says you can't bring that into the US. FDA says your goods are refused. You've got to export or destroy within 90 days. At the same time that customs, that FDA says you're having your refused, can't bring this in, customs then says, I'm demanding redelivery because one of the things that you have with your broker is a bond. The bond is not to protect you, it's to protect customs. So customs holds you under that bond to demand redelivery and to demand that you export or destroy. If you don't do that within 90 days under supervision, which is hard to schedule, you get a notice of penalty, in this case, liquidated damages. You see how they check the box for penalty or liquidam on the right, and it's up to the amount of your bond, 50 grand, a lot of money. You don't want this to happen to you, but I do say never pay without a fight, never actually have conversations with your counsel. So I was talking about your top 10 tips. This is where you download it. And this is where that HTS is, and number 4 with, so one of you asked about the HTS link. So it's right here in reviewing your HTS. You get your binding rulings, you have your reasonable care checklist, you've got your importing into the US, you have stuff about recordations, all of the tips kind of summarized. One other thing I will mention to you before I look at that last question is I don't care where you get your news, but you need to get news. I told you there are 47 agencies. They don't play and they update their rules all the time. It's nonstop. You need to keep up in this crazy fun industry. It's an amazing world of importing, but there's a lot of obligation. There's a lot of risk, and you've got to have steps and a process in place. What's your process for ensuring you have the right classification in place? What's your process for ensuring you have the right valuation? What's the process for ensuring you're using the right country of origin? What's your process for ensuring what China tariff does or doesn't apply, whether an exclusion does or doesn't apply? All of these require thought process. Every month, we update our clients and everyone on our list with what's going on in our newsletter, what's going on in the trade world, events like today's. So huge thanks to the SBDC for hosting today. So many useful links. The side-by-side comparison, informed compliance publications, which are amazing. You want to know, there are awesome links to everything you can possibly think of. And that's the hard part because customs has amazing resources and they get upset if you don't use them because they have them. We do so many trainings on navigating detention, seizures, building your import compliance plan. I would love to see you guys do, and more intros to importing as well. I told you you'd see the cutest dog in the world. This is Lucky. He's our head of security. So when you come visit me at Diaz Trade Law, you get to meet Lucky. And I would love all of you to keep in touch on LinkedIn. If you scan that, you can keep in touch with us on LinkedIn as well. And Shelly, I know I was trying to answer all these questions as they came in live. I think I did miss one. If you want me to look at that now, or if you want to close up, your call, because I know I like to stay on time and we are like right at that time.
Yes, we're at the time. But you did provide all of your contact information for everyone to reach out to your office. And I would like to remind everyone that another poll is coming up from the SBDC. But Jennifer, I know that I speak slowly, but now I realize I think slowly too, because I was really focusing and it was difficult for me to keep up with how fast you were rolling. But thank you so much for sharing all of this information and resources. I happen to have a digital library, and so every time I go to your website and I conduct searches, what's amazing is that your search function works. And I actually can find what I'm looking for in the library of resources that you provide. It's an incredible tool that I also recommend to everyone on here. Thank you for attending, everyone, and thank you, Jennifer, for your generous hospitality and providing all of this information. And I look forward to continuing to work with you in the future.
Thank you. Appreciate the opportunity to speak with all of you. I know I speak quickly and there's so much to learn on all these fun topics. So very happy to be a resource, and thank you, Shelley. And I encourage all of you to reach out to Shelley with all your questions as well. So many trainings, so many, and everyone wants to also ensure that they get access to the PowerPoint, which I did tell them that you're going to send them. So the SBDC, I believe, will be sending you the PDF directly. So you'll get that from them as well. And I'm happy to keep in touch with all of you. Thank you.
Take
Take
care. Have
care.
a good day.